個人。
We've just formed a quorum and it's the appointed time. Would you please invite the administration to join us?
咁喺呢度咧，就想同大家睇睇嗰啲會期啊，因為咧就係、
I would like to look at the meeting times for us. The administration proposes another meeting on the 25th of July at 8:30. Well, it will be the summer, and no matter how fast we move, we can only finish things after October. Perhaps this will be our last meeting before the summer recess, and after the summer recess, we will see how we goes. Well, I don't want us to rush only to have a meeting aborted. Let's continue. There are two items. In the last meeting, we see that members had put forward some different views. Perhaps if the Deputy Secretary is ready, he can take us through the papers. They are CB bracket 22056/13 to 14 bracket 0102. And also CB bracket 21775 1314 bracket 02. Could you please quickly go over the meetings with us? Well, we have set out the concerns of the deputations and individuals in a table, and we have had another round of discussion with the stakeholders to explain to them about the progress of the bill's scrutiny. In response to our explanation, these bodies have been writing to the Bills Committee, and all the views have been incorporated in our paper. We've also annexed their letters as well. We see that it seems that the major area of concern is written order of drug, and also the code of conduct and the code of practice. Well, since the drugs incident in 2009, we had a review committee set up. Only 16 of the recommendations out of the 75 recommendations of the review committee involved legislative amendment before they can come into effect. One of them is about written order of drugs. We don't have the power under the current legislation to set down a code of practice or code of conduct to require that orders have to be made in a written form and the record kept. So if there is any problem between an order and a distribution, there will be problem. If we cannot set down the code of practice or the code of conduct, the situation will revert back to the situation in 2009, because there is no additional safeguard between order and delivery to avoid misunderstanding. because, well, without the record, you cannot cross-check during delivery whether they are the actual drugs ordered. So this is to protect patients. And we understand that written orders is not as convenient as telephone orders. We accept electronic orders, say WhatsApp and emails. We discussed in one of the Bills Committee meetings that the doctor ordering the drugs don't have to place the orders in written form, but the one who receives the order will have to reply in a written form. Well, I'll stop here. Thank you, DS, for the explanation. Let's see if members have any other views. We have about an hour or so. Let's see if there are any views. We have 3 members. Maybe 4 minutes each. Mrs. Virginia Ip, you are the first one. I read out your name first, but I did not hear that. Mrs. Ip. Sorry, I have to apologize because previous meetings often clash with others. When you talk about making orders in written form or even electronic form, but what is the practice overseas? They are similar, but there's something special in Hong Kong because doctors can dispense drugs, but overseas there is a separation of prescription and dispensation. So when it comes to practice, it's different. What about places closer to us, Singapore, Taiwan, or the mainland? Orders have to be made in written form because as long as there is separation of prescription and dispensation, then there is a written form. Well, you've heard from the trade what are the difficulties they have voiced. Well, we don't really understand where the difficulty actually lies. The doctor makes a telephone call. Then the pharmaceutical company reply in written form. That suffices. So we understand that it should be implemented by phases. The most serious ones of poison will start first because under the poison list there is part 1, part 2. Well, in the end, we hope that they will all understand this is to protect patients, and there have been incidents showing that indeed something can go wrong. But very often in clinics, the drugs are actually free gifts from pharmaceutical companies. What happens? Well, nowadays, it's not common practice to give away drugs as free gifts. So it's not common to send out samples That's why we require that at the time of delivery there should be a written record and the record should be kept. This gives a chance for both parties, of the one placing the order and the one receiving the order, to have some record to base on. It is just like contamination of drugs. If there is no record, then you don't know which batch has been used and which batch has been contaminated. So written record facilitates tracking as well. Well, I think samples is different from written order. But when it comes to sample, maybe there are some new drugs and they're given out by pharmaceutical companies for clinics to try. And if we talk about a written order, it means that if I want, say, drugs A, B, C, previously I only have to do it by making a call. Now has to be in written form, whether it's by letter or by email. I place an order with the pharmaceutical company and then a delivery will be made.
Ms. Claudia Mo, I think the explanation has been clear. In 2009 there were drug incidents, and that's why we have to tighten up the regulations. And we're particularly concerned about the problems arising between the process of drugs order and drugs delivery. There are no records required to be kept, and after the amendment of the ordinance, and there is this requirement. But what is the underlying principle, and what is the trade's thinking about this? Because the trade believes that it should be the trade which should be undertaking the responsibility, and they don't want to be regulated by the government. They rather want to do it on their own. Now, up to yesterday, the Hong Kong Pharmacists Union placed a very big advertisement in the Oriental Daily listing out their demands. And obviously, you haven't been able to come to an agreement with them. Well, it's such advertisements are very costly, and they've really carefully considered the wordings on the advertisements before placing the advertisements. You still don't understand their difficulties. Can you try to ascertain again what problems they are facing? Deputy Secretary, I think you have listed out the issues in your paper. It's not that we don't understand their problems. It's that their claimed difficulties in placing written order of drugs is much more than we expected. Of course, we can do it require them to do it on a voluntary basis. In fact, the Hong Kong Medical Association has issued a good dispensing practice menu requiring doctors to place drug orders in a written form. But then this is a voluntary menu, and it is not mandatory. So to date, the trade has not been following the requirements in the menu. And actually, after 2009, the Medical Association has already issued this menu, and we don't see anybody following that menu as of today. And also for the several pharmacists' professional bodies, they have also issued codes of practice which are voluntary in nature. But the codes of practice haven't spelled out such detailed requirements on placement of orders of drugs. So it seems that we have to do it by way of issuing such guidelines through the PPB, Pharmacy and Poisons Board. Another thing that we are aware of is that even if the professionals are willing to place drug orders in written form, we're worried that because the market competition is very keen. Well, even if they would like to do it, then they would really like to take the easy way out, and they will become more competitive by that. So ultimately, nobody will be willing to implement the requirement. So we believe that by way of legislation, we can require the pharmacists to do so. So is it the case that you don't have trust in the pharmacists, and then in the way in order to gain business, they would do it in a more convenient way? Well, that's the same for medical practitioners. You can trust, and you don't trust the doctors, and you're worried that they may be selling ketamine and so on. Well, we're talking about the drug dispensaries, and also the distributors, and also the manufacturers here. So they would really like to go by the easier route, i.e. without the written order of drugs. So I would like to clarify that the code of practice is really on the drugstores and not the pharmacists. Mr. Leung Yiu-chung, I would like to ask a question about the communication between the administration and the trades. Now, who is telling the truth and who is not? And the Deputy Secretary has been telling us that she's been speaking the truth all the time. And then she also said that a number of organizations have written in to give their views. Now, if the communication had been good, then the organizations would not have written in to give their views. Now, second, and she said that they had written back, but they didn't actually see the organizations. So what kind of communication is that? It seems that the administration hasn't really understood the gist of the problem. The Deputy Secretary said that she doesn't really understand what their difficulties they are facing. So in that case, why don't you talk to them more, discuss with them more? So, Chairman, can I suggest that the Deputy Secretary or even the Bills Committee can spend more time to discuss with the trades and ask them to explain clearly the difficulties confronting them, and see if the administration can make some allowance or relaxations. Now, as what Miss Claudia Mo said, the union was spending time and money to take out advertisements, and that goes to show that they do have great grievances which cannot be channeled appropriately to the administration. So, if that is the case, why don't we give more opportunities to the trades to give their views to us? For issues that the administrations are not clear about, why don't we give them more time to explain their problems to us? It's better to do that than having the Deputy Secretary rehashing her old lines over and over again. Second, the Deputy Secretary said that she doesn't understand why the trade doesn't want written orders of drug. I've talked to the trade recently, and I've gained more understanding on the situation. Now, for a certain type of drugs which is running out of stock, the drugstores can talk to the sales and try to negotiate some other types of drugs. Well, it's not as simple as what you thought, just checking the box on a form or a list of drugs. Well, it's often the case that the drugs may have substitute drugs, and there are different tastes of drugs, like those for children especially. So all these issues can be discussed, say, through a telephone call. It's not like we ordering dim sum in a Chinese restaurant, taking the the boxes, and well, there are still problems. Well, in a Chinese restaurant, certain dim sums may go out of stock, and then they will come back to tell you that you have to order something else. Now, the same goes for the ordering of drugs. There are times when certain drugs may run out of stock, and such problems have to be resolved. So I think the administration should discuss further with them on such issues. And you are not talking to them. So this is most inappropriate. Well, what they're concerned about is not just about the written orders of drug, but also many other issues. So, Chairman, would you consider inviting the deputations to come and give their views again? First, I'll tackle Mr. Leung's first point. We have held several meetings in this session, and we have heard views from the deputations loud and clear now in public hearings. We have also held public hearings under the relevant electoral panels. And also the administration has given us piles of papers on their communication with the trades. I don't know I can't tell who is telling the truth and who is not. But because we have a rather heavy schedule. Well, let's try to follow up on what we've left last time. Actually, we have already started the close by close scrutiny last time, and in the process we have said one thing, and that is many of the points in this marked up copy have to do with technical amendments. We are still staying with page 7, which is on the codes of practice. And if members have great interest, strong views on that, then we can discuss that. And then we turn over the page again. And if we're satisfied with the explanation given by the administration on the technical amendments, and we can go back to the earlier issues. Now, today we have many members here. If you think that this arrangement is inappropriate and you're not happy with it, and we can do it in another way. But if everyone is happy with the approach, we can follow what we suggested early on. Now, we are coming to the summer recess, and the LegCo is taking a break, and this will be the last meeting of this bill committee. And members may be of the view that the administration has not been communicating well enough with the trades. Then the administration may take the opportunity of the summer vacation to talk more with the trades. Now, Mr. Leung also mentioned about the point about placing drug orders through telephone calls, and the very complicated issues involved. And well, I remember the administration saying that you can start first with a telephone call and then follow up with a written order. So is that feasible? The trades may have differing views and whether it works or not. Now, this is the last meeting of this Bills Committee, and I think the administration should spend the summer vacation in further ascertaining from the trades whether such arrangements are feasible. And I don't think there is a need to further convene or hold public hearings anymore. So perhaps the administration can respond to Mr. Leung's points. Well, we have given a reply in the previous meeting. Now, we can have first telephone calls before placing a written order of drugs. Now, perhaps in a telephone call, 5 drugs may be mentioned, and then the sales can follow up with an email listing out all the drugs that have been ordered, and then the doctor can return the email, say through a WhatsApp or what. So because of all these uncertain factors, we need certainly a written form of the order of drugs. Now, after the 2 public hearings, we have also approached different trades and organizations and conducted briefings for them. And last time, the members also asked whether we should understand more again from the trades. And so after that last meeting, we also approached all the organizations again, and we asked them to write in to confirm that they have talked to us. And we also invited many organizations to sit in for the briefing. So every time we heard views from members saying that there was inadequate consultation, we went back and did more consultation. So after the last meeting, we begged the organizations concerned to write in to us again on the issues of concern again. So if members could tell us which organizations we should talk more, then we are more than happy to do that. If you give us a name. We also have approached the Hong Kong Pharmacists Union, and we didn't meet with them ultimately because they said they need a legal consultant to be at the meeting. But anyway, we've done all we can. And in the past week, we asked them to write in clearly on their issues of concern. And why this big pile of documents is precisely because members were asking us to do more consultation.
Mr. Leung, perhaps you wait for the next round because there are a number of members waiting. I just want to reply to a point raised because I didn't understand. You talked about this is the last meeting. I understand that I was talking about after October, not this time. So you have misunderstood me. Well, what I said is in relation to the public hearing. I wasn't asking for the public hearing to take place before summer recess. I was just saying that this should be the last meeting of this legislative year. But there is another meeting scheduled, but it will be well into our summer recess, and perhaps we can wait. And there is also a mention about a public hearing, and on a number of occasions, so we have mentioned about the public hearing, and as to whether there is sufficient communication, well, is quite subjective. We have the letters, we had public hearings in panels and in Bills Committee. I think what you're talking about is not unique to this Bills Committee. It appears in other Bills Committees as well. A few meetings ago, we decided to start the clause by clause because a lot of the amendments in the marked up copy are technical amendments. And if we go over a point when members don't agree, and if the administration refuses to budge, then members are free to move CSAs. I think there is no need for a public hearing because another public hearing will be on the same thing. Well, unless there is a new point that has not been discussed. If we have a public hearing simply because a member cannot attend a certain meeting because there is a clash, then we will have endless public hearings. If you don't see eye to eye with the administration and you truly believe that that is necessary, then members, you can move CSAs. And we will have another discussion in the council meeting. Mr. Alan Leung. Yesterday, there was an advertisement. I believe the chairman and the government officials have seen this. Those who have taken out this administration is taken out by the Hong Kong Pharmacists Union and a number of other associations and bodies and a company taking out the advertisement. They are professionals. They have made serious allegations. They said the administration put up a bogus consultation, and in effect they are misleading the public. They have concealed the facts. They pull rules over the eyes of everyone, and they just wanted to muddle through. If they fail to communicate with pharmacists and doctors, and as a result they have to resort to putting out an advertisement of this size. Yet, they still want to bulldoze their way through. I think it is most undesirable. Unless you can tell us that this group of bodies are doing this for their own benefit and with bad intentions, disregarding the interests of patients, and they put up the advertisement because they want to protect their own benefit. They want to keep the profit. Then it will be a different scenario. Oh, but we're used to it. The CY Leung government they listened, but they did not hear. We were talking about something with far-reaching implications. Yes, the chairman said that there are a lot of technical amendments, but after having read the advertisement, I think there is a point there. Many of them attended our public hearing. They have reached a stage when they think they have no other alternatives but to take out an advertisement. And that itself is saying something. I have some questions about written orders of drugs. So I asked my doctor's friends. And I was told that the sales department of pharmaceutical companies work round the clock. So even if it's 3 o'clock in the morning and a patient requires a certain drug, well, the service is still provided. But at this time of the day, maybe the office is closed and there is no fax machine. If you require written orders of drugs, I think that patient will certainly die. So what is the objective of the policy? The DS said that, well, there may be some drugs that cause harm, and you want to trace it. What about an invoice? An invoice will be issued to charge the customer, and it's an invoice issued by the pharmaceutical company, charging, say, 300, 500. Why can't it be used as a way to trace the drugs? Well, there has been previous occasions when an advertisement has been taken out on 3 different newspapers as well. But the advertisement may not be under the scope of discussion this time. But point 4 is relevant. Mr. Leung mentions a scenario where services provided round the clock. There's an HMO. So I would like to hear from the administration. First, I'd like to say that the points made in the advertisement have been made before. It's just that it's not in the form of an advertisement. Mr. Leung also asked whether you can show us that they are doing it for their own personal benefit. But whether it is in the form of an advertisement or in the form of a letter, we attach the same importance to them. We told the trade that we've had different rounds of consultation and they should express their views. There is an association of hospital pharmacists. They have sent a letter to editors in local newspapers, and they have also sent the same letter to the LegCo. The letter says that they support the bill. When it comes to the clinical trial certificate, the period, code of practice, code of conduct, well, it says that they support written orders of drugs because it's only in this way that patients' rights can be protected and future drug incidents can be prevented. I think Mr. Leung was talking about point 4. That is, during an emergency, doctor would like to use a certain drug and it cannot be obtained. But one of the bodies takes up about 80% of the drugs in Hong Kong. It says that written orders may not be slower than telephone orders. If 3 a.m. a doctor would like to obtain a certain drugs and a call is made to a salesperson to obtain the drugs, well, that is, we're talking about something related to the code of conduct. Is not a contravention of the law. When there is a breach of the code of conduct, then there will be a disciplinary hearing of the PPB. And I believe that in such an emergency situation, the PPB would consider that to be a reasonable explanation. And during an emergency, 3 o'clock in the morning, can the doctor wait for the salesperson to go to a place, get the drugs, and deliver it to the clinic? Or is it safer to send the patient to a hospital? We're talking about a reasonable explanation. I know that I have overrun my time. I have used more than my time. Why can't you use invoice? I know that you want to achieve a policy objective by requiring written orders of drugs. It's about traceability. Mr. Leung, can you maybe elaborate in the next round? Yes, it's up to you. There was explanations about why an invoice cannot be used. If you're talking about the spirit of the legislation, I think the amendment is to tighten the requirement to safeguard patients' interests. I wonder whether written orders of drug is so difficult, resulting in perhaps patients not being saved or doctors not being able to prescribe. If that is so important, we will have to ensure that we can effectively regulate drugs, we have to ensure traceability. We're talking about who places the order. So if you're talking about the spirit of the legislation or the amendment, they are to protect patients. We've been talking about written orders of drugs, but there are many different aspects in the bill. If we spend so much time on written orders, spending a lot, and we spend a lot of time coming up with different scenarios in which written orders will result in death, I don't see how this piece of legislation can help patients.
No, Deputy Secretary, many people are accusing you of lying and not communicating with the trades. I don't know who is actually telling lies. I think I've said before, we should not be the judge here at this meeting room, judging who is telling the truth or not. I would like to focus on the spirit of the legislation, i.e. to help the patients. I would like to talk about the issue on authorized persons, AP. And to the layman, AP should be one who studies, who has studied pharmacy. But then in your amendment, this is not necessarily a requirement. So is that a relaxation on the qualifications or eligibility of the AP? Can you explain? I fully agree that the main reason for the amendment is to improve on the drug safety for patients, and the background is the drug incidents in 2009. And if we don't have a code of conduct requiring written orders of drug, then we would be going back to the time when we had in 2009. We've received many submissions from patient groups alleging that we've conducted so many consultation sessions and we've conducted a lot of assessment. When would you actually implement the requirement? Well, we are very keen to get this through, and of course we respect the legislative timetable, and we are also continuously consulting the trades. Every time members said that we haven't done our work properly, we will go to do more consultation time and again. Now, Ms. Mack, you mentioned about AP. We said that this is modeled after the EU standards, but internationally, we recognize that the US standards are on the high side. The APs can be persons other than pharmacists. This is not a retrogression or going back. Now, let me cite the example of a microbiologist, for example, Professor Yun Kwok-yung. Well, he can also be an AP. A doctor may be very well versed in pharmacy knowledge, and he has studied for 3 years in the GMP program. Now, why can't we allow him to be an AP? Now, apart from that, there are experts from the pharmacology field, and they can also be AP. And our requirement is that they should hold a master's degree. So it's not a going back a step backwards. I think all these people have contributed a lot to the pharmacy industry, and I would not say that having these people serving as AP is a step backward. Mr. Wang Tengguang. About this ordinance, I think the spirit is upholding public interest. In 2009, there was this drug incident. We should have zero tolerance, and we wouldn't want that to recur. from 2009 to now, 2014, it's been 5 years. I think we should proceed as fast as possible. 5 years have already lapsed. We are now scrutinizing the bill, and we can still move amendments. And I think there is one principle that should be upheld. We should have zero tolerance on drug incidents harmful to members of the public. Second, we heard this view all the time in the electrical, objecting the insiders, regulating the insiders themselves. Now, how come that we now are putting in place a piece of legislation to regulate the professionals? How come that there is such a strong objection? Now, some members said that there is inadequate consultation. I think the administration has communicated a lot with the trades already. It's not the case that there is inadequate communication. I think it all boils down to a conflict between the regulator and those being regulated. Different people have their own stance. Conflict between the regulator and those regulated, well, there's no way that these two parties can come to an agreement on anything. So why is there so much strong objection? Because, well, put simply, there was no regulation in the past. And now, in the future, there will be regulation and penalties. So if you are regulating me, then I would also go against you as well. I also noted that there is an advertisement taken out in newspapers. 5 points are raised. And I don't think all the worries are 100% true. On the 3 allegations, I have a strong resentment. And it says that the administration's approach is an insult on the wisdom of electoral members. I think members are looking very carefully at the bill, and we're listening to both sides. And how can you say that the administration is imposing an insult on the electoral members' wisdom, and the administration is trying to muddle through? Well, I don't think the government can do that. I have my own stance, and it is very clear, and that is everything should proceed on the basis of protecting patients and members of the public's interest. So that's very fundamental. Now, I have a question. There should be records. Well, can we have taped telephone conversations? Can that be serve as records? Taped telephone records. Now, it's difficult to tell the identity of the persons on the telephone calls, and I don't think it can be implemented easily. Well, there are so many telephones placed in different places all over Hong Kong. And why are we worried that telephone calls are not good enough? Because telephone calls can be controversial, and because minute differences, cannot be easily identified in taped telephone conversations. I think in the trades, in important transactions, in financial institutions, and so on, we conduct the transactions through telephone calls, and they also state clearly that the telephone calls will be taped, and if there is any argument in the future, the telephone calls can be adduced as evidence for dispute resolutions. And telephone conversations can be short or long. Well, perhaps the person taking the order can repeat verbally the order placed by the doctor or the orderer. And then, once that is confirmed, then there won't be any problem. If I were the salesperson, I would state clearly that, oh, you are Dr. So-and-so, and the dosage or prescription is so-and-so, and the name of the drug is so-and-so. And then I would ask detailed questions on that. And then if the other party confirms it's yes, then that can be very clear. And can that be used as evidence? Let me put it this way, Chairman. Telephone orders. Well, the written drug orders can be preceded by telephone orders. Now, say in transactions of shares and so on, there would be a written confirmation order afterwards. Now, it's all right that we have a written order afterwards, but then if we are relying merely on the telephone orders, and that is not good enough. Can you go by what I suggested, and then the sales person of the pharmaceutical company can follow up with a written order and then duly signed by the doctor? Can that work? Well, it's not the case that we are not allowing you to use telephone to place an order, but what we're suggesting that it should be followed up by a written order. Yes, would that be written down in the code of conduct? Yes. Well, we're not banning telephone orders per se, but we require that a written order should be put in place. Well, it's just like a dim sum order form. Well, I suggest that you refrain from using the term dim sum order form, or else you'll be under criticism again. Mr. Peter Zhang, I'm also concerned about the written orders of drug. To my understanding, the administration is proposing this so that in case there are drug incidents, they will be able to trace where the problems arise and take out prosecution if necessary. My questions are, number one, I have also thought about the point raised by Mr. Leung, Alan Leung. Can the order form or the invoice work, or the confirmation of the order form work? Are there problems with such confirmation order forms? Please respond. Now, second, if there are no drug incidents, but then we find that somebody is breaching the law, would you take out prosecution also? Now, if nothing untoward happens, then the breacher may be let off, but then you may do surprise inspections and you identify certain irregularities or breaches of the law. How are you going to deal with those cases? Third, fourth point in the advertisement. The mandatory written orders of drug that cannot guarantee the patient's safety. I can understand the first part, but then I don't understand the latter part of that paragraph. How come that with written orders of drug, the things mentioned in the latter part will happen? I don't understand it. Can the administration explain to us? Well, nobody taking out the advertisement is here, so I would like the administration to respond. Thank you, Chairman. Why the invoice doesn't work? Well, when the invoice is issued, the drugs have been distributed and used, and it's a one-sided way of doing things. It's just the drugs company sending out the invoice to the doctor, and the doctor doesn't confirm it. Now, there may be cases where the doctor is ordering drug B, whereas the drug A is delivered. So by the time the invoice is received, the drugs may have already been used, and that's no good. So in the drug order, then we will state out clearly the types of drugs ordered, the prescription, the dosage, all the specifications will be laid out. And these may not be in the invoices. These details may not be in the invoice. And we understand that in the practices, established practices in the field, there may be discounts of drugs and so on. So these are problems or complicated issues. So that may not work. Say, well, let me cite an analogy. Say, in a dim sum order form again, I may be ordering a barbecue pork bun and not the rice rolls and so on. There may also be cases that where the order is for drugs A, B, C, and then ultimately drugs A, B, D are delivered because some drugs may have run out of stock, and there is also a time gap. Now, as for the relationship between written orders of drug and the emergency cases, I have also replied on that point. If the patient is really in an emergency condition, shouldn't he or she be sent to an A&E department instead of having the doctor ordering certain drugs for the patient? Would those things not happen if it is if a drug is ordered via telephone call? Now, as I said before, a drug company supply over 80% of all drugs used in Hong Kong. And they said that there will not be any difference in the timing of the delivery in placing orders through telephones or through written orders. Well, the drugs companies are very concerned about this point as well. So I hope that members can understand this point.
If you made an order in the middle of the night, in such an emergency, you still have to communicate with the salesperson. What if it's an emergency situation? Well, with my limited knowledge, an oral or a drug taken orally will take a longer time than one that is administered by injection. That is another point. Breach. According to the existing code of practice, where, as I said, that the written order is not part of the bill. Is the case that the PPB is empowered to formulate guidelines or codes, and in the code is stipulates a requirement of a written orders. When there is a breach, it's not a breach of the law, but one that is subject to disciplinary hearing. When there is a breach of the code of conduct, it will have implications in renewal of license. And I think that it's more important to have the mistakes rectified than have the person prosecuted. And because we're talking about protection of patients, if we can prevent mistakes from happening, it will benefit patients more. And I believe that if it is in written form, people will pay more attention. Blatant mistakes can be spotted very easily. Mr. Albert Chan. You may recall when we were discussing about 4B, we were supposed to finish quite quickly, but I asked a question. Under 4B, there are the codes of conduct and the codes of practice. And then we learned that is one code of conduct and 4 codes of practice. There is only one board involving 4 different trades. I understand that this is a trade that is very complicated. It's an inherent flaw. You use one piece of legislation to regulate different trades. That's very important because we're talking about manufacturers, pharmacies, and professionals. It's very complicated. Well, for a certain trade, they may be very happy to be regulated. Say, nurses. If you say there is a single piece of legislation regulating nurses and doctors, the nurses will be up in arms. If you change the pharmacists to nurses, I am sure that they will be very unhappy. Well, they are my constituents. That's why the functional constituency has to be abolished. I support another public hearing because I don't understand what is going on. Maybe because I'm thick. I have to ask a lot of questions to each clause. Relationships between the different trades, and what are the relationships, what are the conflicts, is it fair? I have to ask questions in every single clause. How are you supposed to scrutinize the bill? In every clause, I will ask about the relationship among the 4 different trades, and then you have to give me a written reply. We have to spend a lot of time on 4B, because I will ask you of what are the views of the many different bodies. I have to learn about that before I endorse this. We are talking about major incidents. I know that you want to continue with the clause by clause, but it's not just about technical points. We're talking about a chaotic situation, and we may be talking about tens of thousands of amendments. It will take eternity before it's passed. Well, how many pages are there? It's just not me. Miss Mo and Mr. Leung Yiu-chung as well. And I'm sure Miss Mo will introduce 10 times more amendments than I do. I do understand that the DS has been working very hard and they have done a lot of work. But there is an inherent flaw here. This flaw has to be rectified. Well, C.Y. Leung, 689, is incompetent. No matter how hard he works, I will not be satisfied. You have to address the fundamental conflicts first. You have to clear the minds before you enter the field. Otherwise, you'll be blown to smithereens. You'll be blown to smithereens. So I hope that we will have a public hearing after October. Last time we stopped at 4B for the clause by clause. Our approach is that we will spend more time on the discussion when we reach a point where we think is necessary. That's why we stopped at 4B. Mr. Albert Chan has made the points that are also the concern of the trade. This is the 6th meeting. All these questions have been asked before. That's why we have this meaty document containing all the different views. I fully understand that they have been touched before. It's just like the constitutional reform, that we all have our own opinion, and you have to forge a consensus. There are 9,000 bodies. They have made their voices. They have voiced their opinions the month before, last month, and this month. But they're just talking about their own views. You really have to clear the minds before you enter the field. We have to test it out to see who will be blown to smithereens. I said there is no need for a public hearing because it will be about the same thing. How about this? The public hearing will not be on principle. We complete this clause by clause, and on areas of major concern, say for me 4B, we have everything listed out. And the public hearing will be on these areas. That is something new, but we're doing something similar. Let's finish the clause by clause. A lot of the amendments are technical in nature. When we reach a point where members have many different views, then we'll have a discussion with the administration. And then we decide whether there is a need for a public hearing or whether we should do it by way of CSA. Let's continue with this clause by clause. We have the views set out, and then we decide whether we need to have a public hearing. Otherwise, we will be talking about the same thing. Well, I'll have 4B listed. Members think that the document is not detailed enough, and this is in relation to written orders, codes of practice, codes of conduct. We keep talking about the same thing, we're not moving ahead. Let's hear from other members. And then we will go on with the clause by clause. Don't worry if you're blown to smithereens. There are prosthetics to help you. We will be able to piece you back together. Don't worry. Mr. Raymond Wong. Well, without studies, without investigation, you don't have the right to speak. I have only attended 2 previous meetings in this Bills Committee meeting, and I know that you already have 6 meetings. And this is my 3rd attendance. We should start with 4B, Clause 6. But we have spent over an hour on written orders of drugs. This is a controversial bill. Well, there is the copyright, there is the insurance. Well, I have been a member of controversial bills. I am not skilled in this area, but I'm a legislator. It's part of my duty. I think lawyers are more skilled in vetting bills. We have had a lot of discussions on a policy level. Now, we are in a Bills Committee. We have to deal with clause by clause. It's only natural. Otherwise, it's only a waste of time. If you If we reach an area where you have something to say, say it. I won't be long-winded. I just want to go on with the clause by clause. Whether you agree with the policy is already in place and it's been gone over again and again. And I feel I am really worked up with the advertisement. We're only talking about the wording, fake consultation, and misleading. And these words are very often used to describe Mrs. Carrie Lam's proposal. You are professional groups. You're not a politician. I am a politician. And these words should come out of my mouth and not the mouth of professionals. Of course, this bill is controversial because there are many different interests at stake. Legislators will have to reflect on this. Of course, we have to monitor the government. We doubt where there is no doubt. But as a person, you should not doubt when there is a doubt. Otherwise, you will never get a rest. You will never have a rest, but as a legislator, we have to doubt where there is no doubt. And still, you have to first ask yourself, have you read the documents? To be honest, I've only attended 2 previous meetings. So, before I arrive, I asked my assistants to tell me the content of all the documents because my assistant has read it. I got here after I've learned about all the important points. I'm honest, I'm frank. That's why I said what I said.
Paul, there should be a record on this. I'm not saying this to anyone in particular. As a member, you can say anything you want. Is that right, Chairman? Well, you are more familiar with the issue, so you may say something more on the issue, and the public will make their own judgment. I'd like to know what is the next step, or else it will be a waste of time, and I will withdraw from the Bills Committee. Now, the blue bill here is with us, and we're still just up to clause 6, or page 6, clause 4b. Yeah, my assistant has jotted that down for me. So, what shall we do? Now, when will the Bills Committee complete its work, given our space now? I think the chairman should make the appropriate arrangements. He has the responsibility to make the best arrangement. So I have prepared for certain issues to speak on. Anyway, we will come to the clause by clause in item 3. And Mr. Raymond Wong is very good in admitting that he is here for the 3rd time only. And now some members are interested in going back to some of the issues. And I am obliged to give members the opportunity to speak on issues they would like to speak on. So, but then members are repeating themselves. So I would like to suggest that we go to clause by clause. Now, several members still want to speak, and before 12:45, I would like to proceed with clause by clause. Mr. Paul Chair. In this current session, there are 3 controversial bills affecting certain stakeholders, including this bill and the insurance company's bill, and also there will be another bill on the tourism industry. And they all to do have with the converting sort of self-regulation to regulation by the administration. There are bound to be controversies as objection from various parties. On clause 4b, code of conduct, I think it's a relatively minor issue. the code of conduct is rather sketchy compared to that adopted by the medical profession. So I don't think there is a problem here. I think Mr. Raymond Wong is very right in pointing out that before members come to meeting, they should have read all the papers, or else the progress of our work will become stagnated. I think we should get the issues clear before we speak on certain issues. That then we will not waste everybody's time. Now, turning back to the progress of work, there have been strong objections, and one of it has to do with written order of drugs. I would like to say something on this, and then I would like to seek a clarification. As in the beginning, Mrs. Virginia Yip was the first one to speak, and she said that she has registered. How come that she was not included in the list of members? Well, it shows precisely the problem with the telephone calls. Now, I have been quick to make amends. I don't see any problem in that. So this exactly reflects the problem that we're talking at hand. If we're talking about drugs, then verbal communication is not good enough. There are problems, naturally, with verbal communication. So there have been views raised on whether written orders can be combined with telephone orders, and members have also floated the idea of invoices, and the administration explained many times that is not good enough. Mr. Wong also made the comparison about transactions of shares through telephone calls, and the administration clarified that a written order can follow a telephone order. Can the written orders be provided afterwards? And also in the code of conduct, would you be saying that it's not necessary to have a written order before the drugs are delivered, or there would be a grace period, say 24 hours or a week, in which a written order can be supplemented? If that is done, then that would convenience the relevant parties and assure them. Now, some members mentioned about the emergency cases. I think it has to do with administrative costs. Is that right? Small drugs companies used to have invoices only to confirm the orders. Now, if orders have to be made before the drug delivery, then the order form has to be typed up, and that involves administrative costs. Then would that be a worry of the trade? If that is the case, how can the worry be allayed? Deputy Secretary, the legislative intent is to prevent mistakes happening between the time when the drugs are ordered and they are delivered. So we require that the orders be placed before the drugs are delivered, because if we allow for orders to be supplemented afterwards, the drugs would already have been used, and then that would undermine our purpose on preventing drug incidents. And then what's important is you check the drugs against your orders, and then the recipients can check the drugs against the orders placed. Now, what's happening now is that a telephone call is made, and then someone, probably the courier, will deliver the drugs. And then the recipients will just sign off the order to the courier upon receipt of the drugs, and then there is no matching going on. And then everyone thinks that the right drugs have been delivered, but then problems may arise. So if we have the order to check against the delivery of the goods, then we can minimize the mistakes, possible mistakes. What about emergency situations? When there is an emergency situation, can the order be made afterwards, say within 24 hours? Of course, we will allow for some flexibility. Now, I don't think you should be doing it the way you suggested, because we should not allow them to make an explanation after there is a breach of a code of conduct. In emergency situations, if we are to define what period constitutes, emergency, and what time should be allowed, what period should be allowed for the order to be supplemented in an emergency situation, that is very difficult to do. Say if there is a private clinic working around the clock and there is a need for the drugs to be delivered on an emergency basis, and if there is no way that a written order can be placed and the drugs can just be placed through a telephone call, then that might be considered. Well, if this is what the policy intent is, then they can actually write it down in the bill, include that in the bill. Now, if we discuss that for the issue in the past 6 meetings already. No, I just like to pin down on the controversial point and then try to resolve it. Well, there are all kinds of controversies. Well, Chairman, I would just like to help speed up the progress. I'm not trying to divert here. I think you have misunderstood me. Well, the sitting has already, the full council meetings have already ended, and after the summer recess, I think we should, in the clause-by-clause phase, can deliberate on certain issues which we think we should discuss more on. All right, you've gone over time of your 4-minute rule. There are still some members waiting to speak. Of course, I understand that you have your own way of dealing with it. I don't want to wait for another round because then that is going to waste a lot of time. Can I finish my points first? Now, we adopted the approach last time because everybody was so busy and the electrical was not functioning normally in a way. So that's why we adopted the approach, saying that we should thresh out the major issues first, and then we went to the clause-by-clause scrutiny, and then we could proceed with this clause-by-clause scrutiny, and then that whenever there are outstanding issues, we can stop that, and then we can go back later on. Well, Chairman, I have scrutinized many bills. If there is too strict a limit on the timing, then it will not be very productive. Well, I've said what I have to say. Mrs. Yip, sorry, I just gave you only 4 minutes, but for the subsequent members speaking, they were given 7 to 8 minutes already. Ms. Claudia Mo in second round, Mr. Alan Lau, followed by Ms. Alice Mack. What time do I get? 4 minutes. I would like to talk about the legislative intent. Now, we just referred to emergency situations. The doctors will have to make their own decisions on dispensing with the written order, and then he may be summoned before disciplinary proceeding, and then he said he can give the right justification. I think there is a problem with that kind of approach. Of course, we want to protect the public interest in our bill. I'm familiar with the media field. I can cite two examples. The Law Reform Commission saying that stalking is legislative proposals are therefore the public interest, and it has been shelved indefinitely because the media say that we're told to make their cases in the court. You don't have to worry because you have overriding public interest as your defense. But then they are facing this kind of problems day in, day out in their daily work. So that's not the right approach. Now, presently we're talking about getting drugs in the middle of the night, and Mr. Paul Chair suggested that we should do away with the approach of taking the doctors to the court. Well, I think that should be written into the bill. I think you should consider that. I don't want you to shelve the bill indefinitely. I think you are doing everything out of good intent, but then you are being unfair to the professionals, and they will be under psychological pressure all the time, and that's not fair to them. Thank you, Ms. Mo, and thank you, Mr. Chair, for your comments. When we discussed with the trades on the Code of Conduct and Code of Practice, we have established a working group to discuss those points.
If there is an emergency in the middle of the night, well, the situation is not covered by the views in the many unions and societies, and there is a good dispensing manual, good dispensing practice manual. There is also no mention about dispensation during an emergency. In an emergency, well, you may not make a telephone call just to get a pellet or two. The legislation is about empowering the PPB to put in place codes, and we've said that we have all the representatives from manufacturers, from pharmacists to discuss in the subcommittee on codes. This is a minute point. We propose to use codes because we want to keep flexibility. Ms. Alice Mack, I understand that if there is no investigation or study, then you don't have the right to speak. May I hear from the DS? You talk about written orders. Where does it appear in the bill? It's not there. Exactly. I think you're talking about 4B. Then you should go to the board. You talk to the board about the content of the codes. Yes. We have given a written and oral reply. The bill is not as complicated as you think. In relation to this clause, it is to empower the PPB to compile codes, and the code regulates the parties. If there is a breach, there will be sanctions. And under the code, the board would require written orders of drug. Under each working group of the codes. We will tell the LegCo who the members are. And once the codes have been endorsed by the working group, they have to be gazetted. We need to give them a chance to talk about it. The concerns of the trade can be fully discussed in the working group. It's something that I mentioned previously. The trade doesn't really trust the board. You will have to help the board build up credibility before they can proceed. We do understand that this is an outdated piece of legislation. It was enacted in 1970, regulating individuals, companies, pharmacies, and manufacturers. Because at that time, it was all part of a chain. But now, with expansion of the different trades, they have separated somehow. Regulation of pharmacies is a different issue. We keep an open mind, and patients group said that it will take 10 years to finish discussion about regulation of pharmacies. And they ask us to first put in place measures that would protect patients. So if we talk about separation of prescribing from dispensing, we have to fully explain to professional groups and patients groups again. Written orders is not part of the bill. There are some other areas in the bill that are very important. Say, for example, claiming of costs and fees, authorized persons. They may be more controversial. Perhaps we should leave it to the board to talk about the code of practice. We should focus on the bill, on more important issues. And I'd like to reply to Mr. Wong Ting Kwong. He said it's a conflict between the regulator and the regulatee. And I would like to say, I see doctors all the time. I've asked ophthalmologists, GPs, dermatologists. They are in private practice. They think it's no big deal. They don't feel the pinch of being regulated. These issues have been addressed in the past meetings. We should not quantify because the administration doesn't like quantifying. Perhaps we should go back to the clause by clause. So whether it's part, some, a few, put forward your views. If you're not happy with the answer, move CSAs. If it's some views, some bodies, you will have to at least voice your opinion. Well, it is obviously an issue that stems from the law. It's not an actual legal point. Mr. Bode, it's your turn. Speaking for the second time. I do not object to your approach. Well, a number of members mentioned about the advertisement this morning. It seems that the written orders of drug is a side issue. But I understand that if you refer to the the views. This it says that they think the administration tries to circumvent the electrical by doing it in a code. It may be a minor point. But if you do not iron out these issues raised by bodies, you are only making things difficult for yourself in the future. We all fully understand that all these issues can be resolved gradually. Please consider the emergency situation, the service round the clock. Consider it in the code. Iron things out. I don't mind going back to the clause by clause. Mr. Raymond Wong. We have spent a lot of time on written orders. You think your explanation is sufficient, but it's not accepted. You have to convince members of the Bills Committee that the issue will be resolved. A lot of members don't understand. And it's not even in the bill. It's only in the code. But you have to address and respond to the concern of the trade. We have spent a lot of time to voice our opinion. Well, I think it's for the administration to consider whether they have done sufficient work, sufficient political work on a legislative issue. I think we should pause here if there are no new questions. If you don't mind, we will continue with the clause by clause. Last time we were at page 6, Code of Conduct. Last time we wonder whether it's common practice and whether there are alternative practice in different boards. We pause there. If you have questions about the drafting, then we can continue with the discussion. Otherwise, we will move on to page 7. I would like to defer to Mr. Chan. Thank you. It's Cap 135, Section 5. There are 2 technical amendments. First, there is the addition of a heading, Part 3, Pharmacies, Requirements for Registration and Practicing Certificate. Under subsection 2, a number of words will be deleted. The quarters of the Department of Health in. So it reads, the register of pharmacists shall be kept at the office of the Secretary and shall be open for inspection by any person during the usual hours of business without payment of fee. Why the amendment? Because the office of the Secretary may not be at the headquarters of the Department of Health. Let's continue with the scrutiny. Page 8 is in relation to Section 8, Subsection 3C. When the board conduct an examination and a member is involved, it was the chief pharmacist of the Department of Health. It will be amended as the Assistant Director of Health in the Drug Office of the Department of Health. this corresponds with the composition of the PPB. Section 9. It is in relation to certificate of registration as a pharmacist. The prescribed form is deleted, and in its place a specified form is added. So it reads, upon the registration of a person as a pharmacist, the secretary shall issue to him a certificate of registration as a pharmacist in the specified form. We delete the various references of prescribed form to put in more flexibility. Yes, in the English version it says prescribed form, and now is specified form. What is the difference? Under Cap 138A in the schedule, there is a form that is prescribed, and that is the prescribed form refers to. But sometimes when the wording is needs amendment, we will have to do it by way of legislative amendment, and that's why we change the word prescribed form. Section 10. There are some deletions, and shall be liable on conviction to a fine of $2,000. It is in relation to misuse of a certificate of registration. Under 1B, it reads, makes or has in its possession a document so closely resembling any such certificate as aforesaid as to be calculated to deceive shall be guilty of an offense. It's been increased to $10,000 and 2 years of imprisonment.
10.2. In this section, the expression of forgeries has the same meaning as in Part 9, forgery of the Crimes Ordinance, Cap 200. Part 9, forgery. And that should be the heading of Part 9. Now, that heading has been changed from forgery and related offences. I think that has to be amended. And for Part 9, it doesn't use the term forge, but rather forgery in English, and you may have to fine-tune the wordings here. Mr. Paul Chair. And the official said that would be changed to $100,000. Will that be reflected in the latter part of the bill? Yes. 34, clause 34. Unless otherwise specified, all the offences will carry a fine of $100,000. Is this a fine at level 6, right? Yes. That would be amended too. All right, any other questions? If not, then we'll go to page 10. 10A, and that is registered pharmacist not to practice without practicing certificate. We will add in a section 2A, and that is a practicing certificate must be in the specified form, and that has to do with the fact that the practicing certificate must be in the specified form. Page 11 then. 11. First of all, we will head in a big heading, Part 4, Retail Sale of Poisons. And then in subsection 1, that will be deleted and replaced by this. And then the whole section will say, subject to section 16, a registered pharmacist, body corporate or an incorporated body of persons, bracket seller, is authorized to carry on a business of retail sale of poisons if the actual sale of poisons is conducted on premises registered in respect of the seller under this ordinance by a registered pharmacist or in his presence and under his supervision. This we have added in the pharmacist actually on site or in his presence. 13. Registration of premises, subsection 2. We've deleted the term prescribed form and replace it should be made to the board in the specified form and prescribed manner. So that has to do with the application method. And after subsection 4, there will be a new subsection 4a. Without limiting any other ground on which the board may be satisfied that a person is not a fit and proper person to conduct the retail sale of poisons at any premises for the purposes of subsection 4a, a person is not such a fit and proper person if a, the person is disqualified from being an authorized seller of poisons under a direct made under subsection 16(2) bi, b1, and the period of disqualification has yet to expire. The board shall not register premises under subsection unless it is satisfied in relation to the retail sale of poisons at such premises. And this states clearly under what circumstances the poison sellers can engage in retail business. And for 5a, we also have replaced specified form. We have replaced prescribed form with a specified form. In relation to 13(4)A and C, would you be making the corresponding changes? And 4C, we would make the changes under his supervision, i.e. the actual sale of poisons will be conducted on the premises by a registered pharmacist or in his presence or under his supervision in accordance with section 11(1). And in his presence will be added. Please carry on. Page 13, and that is also a continuation of section 13, and that is 7b. There is a technical amendment. The last two words will be replaced. The board may, in respect of the renewed certificate of registration, impose any condition in addition to or instead of any condition previously imposed by it under subsection 3, and we'll add in the word and then we will add in a subsection C. The authorized seller of poisons must pay the prescribed fee for the renewal of the certificate of registration, because the ordinance doesn't specify a fee to be paid in renewing the license. So that's why we've added that in. Now, after section 7, we are proposing new sections 7a and 7b. And 7a, an authorized seller of poisons may apply to the Secretary for approval to alter the entry contained in the register of premises relating to any premises registered in respect of the authorized seller of poisons. And 7b, if the Secretary approves the alteration, the authorized seller of poisons must pay the prescribed fee for the alteration. And if there are any changes to the premises of the authorized seller of poisons, they can apply for such changes and alterations. There is a punctuation. There is a comma after the register of premises, is it put there because you don't want the sentence to be too lengthy, or rather you put in a comma there? This is really a complete sentence, and you don't want it to read too long, then just put in a comma instead. Yes. Well, we've learned a Chinese a lesson in the Chinese language here. 7A and 7B, is the application made with the secretary or the PPB? Well, we change it to PPB instead of the secretary. All right. No more question. Then we will go to page 14. Section 15, we will add in the new heading, Part 5, Registered Pharmacists and Authorized Sellers of Poisons, Disciplinary Proceedings and Restriction on Use of Titles. Appointment of a Disciplinary Committee, Section 15. There is a change or amendment in subsection 1. The whole entire section will be changed and amended to if A, a complaint is received by the board regarding the conduct of a registered pharmacist or an employee of a registered pharmacist, or it appears to the board that a registered pharmacist has contravened a code of conduct applicable to the registered pharmacist. B, a complaint is received by the board regarding the conduct of an authorized seller of poisons or an employee, officer, or partner of an authorized seller of poisons, or it appears to the board that an authorized seller of poisons has contravened a code of practice applicable to the authorized seller of poisons. C, any of the persons mentioned in paragraph A or B is convicted of an offense under this ordinance, the Dangerous Drugs Ordinance Cap 134, the Antibiotics Ordinance Cap 137, or the Undesirable Medical Advertisements Ordinance Cap 231, or 2, an offense under Section 52, 54, 61 of the Public Health and Municipal Services Ordinance Cap 132, or Section 7, 7A or 9 of the Trade Descriptions Ordinance Cap 362. Any question, Mr. Paul Chair? Or rather, Mr. Raymond Wong. Bracket B. Can you add in the word gone in front of the word fan in Chinese? Well, we can consider that. When we did the drafting of such legislation, we just put the word fan instead of gone fan in Chinese. So they have been convicted, yes. So it looks rather strange to me. Well, it's a matter of consistency, is that right? Yes. All right, Mr. Paul Chair. E. This is an omnibus clause, or encompassing in nature. But judging from the wordings, it seems to empower the enforcement body really too much, gives too much to the enforcement body. Specific details have been laid down in the previous clauses, like the conviction under trade description ordinances, dangerous drugs ordinance, and the undesirable medical advertisement ordinance. That's very clear. But then in E, it seems it's too broad. Is that necessary? Or it will raise the fear among the trade that the authorities are enjoying too much power. Well, subsection E is already in the existing legislation. well, let's look at the parts deleted, line 4, i.e., that the board may, for the purpose of such inquiry, appoint a disciplinary committee, and that well, the new E stems from that particular part. So in the new legislation, you have set out everything so clearly. So is it necessary to have this all-embracing clause still? To our understanding, it is also qualified by A and B. And for A and B, a complaint is necessary, but for E, it's just the test is just comes to the knowledge of the authorities. Now, I'll try to explain here. Now, for A complaint is received by the board regarding a certain thing, and B, a complaint is received by the board regarding a certain conduct of the ASP or the pharmacist. But for E, that covers other situations, and that also has to do with the contraventions of the code of practice or a code of conduct of the relevant ASP or the pharmacist. And we don't need a complaint in this paragraph. So say if something is identified in the course of investigation, then the enforcement may have to take action, and that we need subsection E in order to do that. Now, for A and B, it involves complaints against ASP and also registered pharmacist. Well, that's right. It involves complaints, and that complaint has to do with the code of conduct or code of practice. But for E, these are not the conditions required. It says just that into the conduct of any of the persons mentioned in paragraph A or B. Well, does it necessarily have to be the conduct contravening the code of conduct or code of practice? Should that be categorically stated in paragraph E as well?
I haven't finished. And it says under section 13, if the condition of the registration is convened, and for D, a disciplinary committee may be formed to hear the breach of a code of conduct, and this may not equal to the code of conduct or the code of practice under A and B. Because these are formulated in areas of the operation. But when it comes to pharmacists, there are maybe personnel matters. Maybe it's an ethical issue. The code of conduct will not cover such minute detail. So if there is a suspicion that is something to do with an ethical issue, then it may be covered by the code of conduct. For C and D is about a conviction, A and B conduct, but for E it relates to ethics. Well, so what about throwing a glass or hurling invectives, or says swear words? It may be opening a floodgate. There is concern of too much power being given to the board when it comes to their ethics or their conduct. There has been such a hearing because in a case a professional took upskirt photos. And that is not included in the registration of pharmacists and poisons ordinance. So is it the case that you will take follow-up action after a conviction? We take into account the situation. Perhaps the professional might have done something related to a moral issue. It may be a court conviction, it may be his conduct. It usually is about moral conduct. The previous ones are related to drugs, say for example sales of drugs. Well, with your consent, I would extend the meeting by 15 minutes. I think what's said here is you might have opened the door too wide. And if that is the case, you will have endless hearings. Well, there are other professionals, say for example, other professionals. But don't mention legal practitioners because I strongly disagree with that. Because when it comes to ethics and morality, it's not just limited to the practitioner. If I support the W getting married, maybe for some professionals, I have already breached an ethical code. Well, now that all the powers are under one roof, A, B, C, and D are clearly defined. But when it comes to E, we're talking about the conduct and moral. And there is no mention about it being confined to its practitioner. Mr. Raymond Wong. Mr. Dare has a point. But let's look at E. It otherwise appears necessary or desirable to the board to inquire into the conduct of any of the persons mentioned in paragraph A or B. So A and B involves persons under the regulation. Yes, indeed. Conduct itself is abstract. I think it's not. So paragraphs A and B refers to the conduct, not the people, not the type of persons. If you refer only to the professional conduct, that's fine. But if you just say conduct, I'm afraid the scope is too wide. In relation to the first part of A and B is about conduct. A complaint is received by the board regarding the conduct of a registered pharmacist or an employee of a registered pharmacist. It appears to the board that the registered pharmacist has contravened a code of conduct applicable. So is conduct of a wider sense. But my beef is that it's not clear. And the law has to be clear. You're talking about these two groups of people. And when you talk about that conduct, is it related to their professional conduct or not? Ms. Mack, I do agree with the two other members. E is rather vague. If the DS said that there is a premise of A and B, that is a complaint is received, but E is it appears to the board. And it talks about otherwise. So it's not just about A and B. But in A and B, there is also the word it appears to the board. On page 14, bracket 1, A and B, the second part is not about the complaint. It's about the appearance. So when it comes to the complaint, it's only about the first part. So without a complaint, the board may take the initiative to conduct hearings. Now these are details. I find it strange because the bodies did not raise this issue because they haven't suffered. So it's too wide. I think that's what members are saying, that anything they do, they may be subject to disciplinary hearing, disciplinary proceeding. We are concerned that the provision is not accurate and precise, clear and precise. Perhaps we will look into it. We'll also look at the code of conduct of similar professionals. Perhaps you can narrow it to their practitioner or professional conduct. Leave their personal lives out of it. They may be throwing glass, they may be homosexuals, and it will be out of your regulation. Or if you throw a glass, it may hurt customers. Since members have raised a concern, please consider changing this. Changing this one. Don't just tell us that, there is a similar approach with other professionals or other legislations. I think it will be too rushed for us to make a decision now. Now, I'm not asking you to do it now. In the past 6 meetings, it's always like this. We only have the last 30 minutes to go to do the clause by clause. Sorry, poor leadership. My bad. Please consider. You may say that it's so written in the other similar legislation, but it doesn't mean that you have to do it this way. Let's stop here. We'll have a summer holiday and we will reconvene after September. Thank you.